Hey folks, this is Attorney Sharif Silmi. Welcome to the roadmap discussion. Today we're going to be talking about the National Interest Waiver. Now, for you to understand where the National Interest Waiver stands in the array of immigrant visas that are out there, the within the employment-based category, the National Interest Waiver is a second category employment-based petition. And the beauty is it is one of only two visas that exist within the US immigration system that allows one to self-petition. So you do not need an employer sponsor to file a national interest waiver. So the first thing I want to talk about with respect to the national interest waiver is why should one seek a national interest waiver? Now, you may be, for example, an individual who is already in the US. You are working at an organization, at a company, perhaps on an H-1B visa, and perhaps you even have an existing employment sponsorship. And if you have an existing employment sponsorship, you can still file, and you ought to still file a national interest waiver if you are in a visa backlog. Because when you're on a visa backlog, take, for example, somebody from India, and that individual is in a visa backlog for several years. At some point, the immigration system is going to move in the direction that you will be able to file for an adjustment of status. But if at the time that you file for adjustment of status, your company is having layoffs and your job is in jeopardy, or say that you moved from one company to another and the new company is going to need to restart your employment sponsorship process while a window of availability for visas is open, you are going to lose out. So the way that you could prevent that is filing a self-petition national interest waiver. All right. So the self-petition national interest waiver is available to anyone who either has a master's degree, and even if you do not have a master's degree, you can still file a self-petition national interest waiver. The individual who has a master's degree, you can file without the need of providing any other information in order to qualify for the analysis. So once you're able to establish that you have a master's degree, then the national interest waiver is determined by three main factors, all right? The first factor is that you work in an area that is of national importance that requires substantial merit, all right? Number one, you work in an area of national importance that requires substantial merit. So what this means is the area of work that you're involved in is beneficial to US interests. And this could be from anything, whether it's an economic benefit, it's a benefit related to, take for example, one who is working in the biomedical field. So you are working in drug development, or we have a lot of people who have come to us who are working in a drug trial environment. So those people are definitely biotech eligible for national interest waiver. Even if you are working with children, such as special needs children, that might be an area of national importance. So there's a wide array of positions that can qualify for a national interest waiver. Some people tend to think of a national interest waiver as being related to national defense. That's not the case. I mean, if you are, for example, in a data security role, that is an enormous benefit from a national interest waiver perspective, but it really can be anything. It could be an artistic role, so you're adding maybe cultural value to the US. So there, again, is a wide array of availability for people who would want to file for a national interest waiver. So again, the first requirement for someone with a master's degree is that you work in an area that is of national importance, all right? So once you've established that you work in an area of national importance that requires substantial merit, so it requires that you have a certain skill level that enables you to do a complex job, all right? It requires substantial merit. then the second part of the analysis is that you are well positioned to advance your field of endeavor. You are well positioned to advance your field of endeavor. So what this means is the analysis is going to turn to you and your qualification. How well are you in terms of education, experience? Where, for example, have you worked and enabled things to expand within your field? We've taken cases where individuals have worked in the tech field, like data security, data warehousing, and have demonstrated how those roles can be of national importance and how they are well positioned to advance their field. So as I mentioned, there are two types of self-petitions within the employment-based immigration system. The National Interest Waiver is one, and the other is the EB1A for individuals of extraordinary ability, which we went over 2 weeks ago. So anybody who has heard or understands what is required for an EB1A will be able to compare it to a national interest waiver so that you can determine what is best for you. So with respect to being well positioned to advance your field of endeavor, this is a much easier standard than EB1A, because EB1A for individuals of extraordinary ability requires that you have already achieved sustained acclaim that is recognized within your field of endeavor. So compare that sustained acclaim recognized in your field of endeavor with being well positioned to advance your field. So it is a much lower bar to meet. That is why any professional that has a master's degree that is working in an area of national importance, it could be an engineer, somebody who's an IT person who is, like I mentioned, biotech. You are working in an area of national importance, and depending on your role, your experience, your education, the contributions that you have made, and you'll be able to demonstrate, you will be able to show that you are definitely, among that select group. The last requirement for an individual, this is one with a master's degree, is that they demonstrate that what's called the balance test. Okay, so a balance test comes down to, why do we call a national interest waiver a waiver? We are waiving the requirement that an individual who seeks to remain or immigrate to the US be sponsored by his or her employer. So we are waiving the requirement. So when somebody is sponsored by their employer, they go through a process called PERM. So that PERM process requires the employer to go to the US Department of Labor. So when they go to the US Department of Labor, they make a claim to the US Department of Labor that we cannot find any US citizen workers to fulfill this particular role. And we have assigned what's called a salary that is high enough that it's not going to deter or lower the wages of average workers. So those people who go through that PERM process, sponsored by an employer, they have to demonstrate that they're advertising the job for US citizens before the Department of Labor can certify that a permanent position can be opened up to a foreign worker. With the national interest waiver, we're waiving that entire process. So the government is going to say, okay, we're going to waive the permanent labor certification process. The PERM process is now waived. You need to demonstrate to us that it is more valuable to have you as an individual working in an area of national importance that requires substantial merit, for which you are well qualified or well positioned to advance. This weight of that need is greater than the weight of protecting US workers are going through the permanent labor process to protect US workers. So the number one way that, and this is based on case law, there's a case called Danasar. Those who are interested can look it up, DHANASAR, Danasar. So under the Danasar case, there's two ways where a balance test can be met in terms of a national interest waiver. And this is really the key, which is why we call it a waiver, right? So you really need to focus, if you're going to apply for a national interest waiver, on this waiver criteria. You need to demonstrate that we can waive the labor certification requirement because you're going to be a job creator, right? That's one way. You are actually going to, your permanent presence in the US is going to benefit, is going to create jobs. And you can show this with the data, with statistics. There's all kinds of government reports depending on your profession and your position. Also, one thing that many of my clients have done, and we've done very successfully, is we'll present a business plan that not only am I a professional working, for example, in IT data security, but upon approval of my national interest waiver, I intend to start a data security consulting firm that will employ other, workers, including US citizens. This way, you are showing that you're not a threat to US citizen workers, but rather you're coming in to create new jobs and new roles. So this is really an amazing way, a wonderful way to apply for a green card in the US without the need for an employer sponsor. That's really the key. I mean, where you don't need to have an employer sponsor your petition and you're coming in on an employment-based petition, that's really excellent. So before I get into how you can apply without a master's degree, I want to point out that those folks who are, for example, from India or China, where you are probably on a backlog, a very long visa backlog, you need to think about your family and your individual situation. Of course, there's a lot of discussion about the Biden proposed immigration bill and whether that may or may not lift country quota caps. For those of you who are not aware, the way that US immigration system works is that every country of origin has a designated number of visas. So for the many highly skilled workers who come from India, you have a very long wait time in the professional categories. So you are dependent on, let's say you have a previously approved I-140, and you are depending on that employer sponsorship in order to, wait your term and wait your turn, and eventually at some point apply for an adjustment of status. And we know that, for example, even in the EB3 category, late last year, there was a short time period where a lot of folks' visas became current. But what happened there? What happened was a lot of people had switched jobs and been caught off guard with the change in the visa calendar date, and they were not able to adjust status because their new employer had not filed a PERM application. Or maybe the employer refused to sign what's called an I-485 Supplement J. So an I-45 Supplement J is a required document for anyone who is sponsored by their employer when they adjust status. So if you have a national interest waiver, for those of our friends who are, sitting in a visa backlog, you have no need for an I-485 Supplement J. You have no need for an employer to file your PERM. You can actually pursue your I-485 without any of those needs. And that is really a huge advantage to our, folks out there. So, for example, so here we have a comment that a software engineer with 25 years of experience working in IoT, wireless communication, mobile, is it possible for people without patents and publications? That is a great, great question. And I would say absolutely it's possible. And in fact, we've done many cases, such as the example that this gentleman described, where, for example, recently I just did a case for an individual who was in CRM, which is so they're creating like management solutions for businesses. So how they manage their internal business. That's the products that he's creating. And this case was actually an EB1A, which is 10 times more complex than a national interest waiver. And we were able to work with the client, and thank God we got his case approved. He had a 19-year-old daughter. He was really afraid that she was going to age out because he was sitting in a visa backlog for so many years. And, after the fact, he never said this to me before, but after the fact, he said to me, you know what, Sharif? Before I came to you, I went to 11 other immigration attorneys, 11, and all of them rejected me. And when I came to you, you told me my case is going to be very complex. It's going to be very hard. It's going to take a lot of time, but you have a good chance. If you follow the system, you'll have a good chance. And you were right. It was hard. It was tough. It was hell getting all the evidence, but eventually it was worth the wait because I got my approval and my entire life changed. So Deepak, my answer to you is you have more than 10 years of experience. As you mentioned, 25 years experience. If you're a software engineer, you definitely have a bachelor's degree. So if you do not have a master's degree, you have already met 2 of what are called the E21 Extraordinary Ability Analysis. E21 Extraordinary Ability Analysis. So you're probably wondering, what the heck is the E21 Extraordinary Ability Analysis? This is an analysis that is needed to be completed for an individual to file a national interest waiver without a master's degree. So if you do not have a master's degree, you can still file your national interest waiver with a minimum 10 years experience, a bachelor's degree, and one other category. That could be that you, for example, you command a high salary. You have professional memberships in an organization. You have a critical role for an organization that has a distinguished reputation. You have original contributions of major significance. You have reviewed and judged the work of others. So it doesn't matter if you have patents or publication. You can show reviewing and judging the work of others. You can show that, a lot of other criteria without necessarily depending on patents and publication. In fact, most of my clients don't have patents and don't have publications. And it doesn't matter whether you're applying for a national interest waiver or an EB1A, you can do so without them, without a patent and without a publication. So for example, why is a patent often considered important with a national interest waiver? That is because one element for demonstrating that you have made or that you're at a high level within your field is proving that you have original contributions of major significance. So a patent only proves an original contribution. In fact, a patent does not prove major significance. So what you need instead of a patent for someone who wants to demonstrate that they have an original contribution of major significance, what you need instead of a patent is to have proof that you created some original product or process or application. So you have proof. That could be a letter of originality from your employer. It could be documented evidence, for example, a PowerPoint presentation that you gave about the product. You have some internal documentation to demonstrate that you created this product. That will be enough proof of originality. But in fact, you don't even, for a national interest waiver, you don't need to even prove originality. What do you need to prove? That you work in an area of national importance, that you are well positioned to advance your area of endeavor and pass the balance test. Those are the 3 requirements. None of those 3 requirements say that I need patents or I need publication. That's not true. Publications are one criteria within the E21 analysis in the event that you do not have a master's degree. And if you do not have publication, it's fine because already you have more than 10 years experience. You have a bachelor's degree. You just need one more criteria. That could be salary. That could be membership. That could be reviewing and judging the work of others. That could be performing in a critical role for an organization that has a distinguished reputation. So there's no statutory, there's no legal requirement that one has a publication or a patent in order to qualify for a national interest waiver. And if you need more information regarding applying for a national interest waiver or determining whether you may file for a national interest waiver, please call us 443-329-2929. You can email us or send us a direct message and we'll get back to you. So definitely you can pursue a national interest waiver. So those individuals who are in a situation where they do not have a master's degree, and you, for example, you either have an existing EB2 PERM, permanent labor certification, through your employer. Maybe you're thinking about changing jobs. Maybe you're thinking about, what if there's layoffs at my company? One thing people don't realize is if your employer has had layoffs. So if we, at some point, things are obviously not quite stable right now. Nobody knows, some sectors are doing well, others are not doing so well. Take oil and gas. I mean, there's been huge layoffs in oil and gas, and there's probably gonna be more layoffs. So if your company has had layoffs, they're not gonna be able to do a PERM for you. You cannot do a PERM labor certification to hire a foreign worker when you've just laid off existing employees. So what are you gonna do in that situation? If you've changed employers, your new PERM is not gonna go through. You can rely on a national interest waiver because this is completely under your control. You can make the case that you're gonna start your own consulting firm. You can make the case that you're performing in a way that's advancing your field. You're bringing some special set of skills and ideas. And I can tell you that for the most part, people who come to us without necessarily being ready to apply for a national interest waiver or any other kind of, for example, an EB1A visa. We're taking people from the point of just, figuring out what is in their best interest, looking at their whole profile, determining what I call the all of the above approach. You are, your family situation, maybe, needing certain intervention, such as those who might have older children who might be aging out. You need to take certain measures and steps to protect your interest. And that might be a national interest waiver. If tomorrow, comes, today's, even sunny and bright and warm in the East Coast, but tomorrow there might be a big storm and things get very dark and ugly, and you need to be prepared for that. So one way that you can prepare for that situation is through having a national interest waiver, because you'd never know what's going to happen with the employer. And this can have a big, huge impact on you and your family. Another thing that people tend not to understand is that a national interest waiver can also be applied from outside of the US. So if you are in a field of national importance, let's say you're a researcher, I mentioned biotech or data security, we file many national interest waivers for design folks, particularly from Europe, who are interested in coming to the US. Also entrepreneurs. So those who have had success in business can file for national interest waiver as well. There's a whole gambit of areas in which an individual can file for a national interest waiver. It's not only, for example, someone who is in defense contracting or what have you. There are many areas. In fact, one of my favorite, recent cases was for an artist who, made, really beautiful paintings and, showcased her artwork and, was able to successfully file a self-petition that was approved. So, there's all kinds of areas of endeavor that one may be involved in that will allow them to file for either a national interest waiver, an EB1A, or, one of the other criteria. So, again, if anybody has specific questions related to their own, needs, I definitely encourage you to call in. Every case we take a uniquely tailored approach to each and every case. So a lot of, times there's chatter, in the various forums and, immigration forums, and it seems to be like there's a one size fits all approach. The reality is that's not true. There are always individual facts and ways to extract, facts from within a person's profile that, can really impact them and make a huge difference. So I would always, encourage everyone to really dig into their profile and have, call us. We'll definitely help you in terms of digging into your profile and finding a way to make sure that you can qualify. So whatever your role is, and if you have memberships and professional organizations, that definitely helps, and the various areas that you will be able to demonstrate the national interest waiver. So to recap, we're talking about the successful approach for a national interest waiver, and that is determined by, number one, if you have a master's degree, you can automatically file, and you need to prove three things. Number one, that you work in an area of national importance that requires substantial merit, that you are well positioned to advance your field of endeavor, and that you pass the balance test. And the balance test is there to determine if the government should waive the requirement to have a permanent labor certification filed on your behalf. If you do not have a master's degree, you can still qualify for a national interest waiver through filing what's called the E21 Extraordinary Ability Analysis. Like our friend Deepak, you have 25 years, you don't need 25, you only need 10 years of experience, have a bachelor's degree, and meet one other criteria. That can be professional membership, it can be publications, it can be reviewing and judging the work of others, it can be performing in a critical role for an organization that has a distinguished reputation, that you have original contributions of major significance to your field of endeavor, you have been mentioned in the media. So any one of those criteria plus 10 years experience and a bachelor's degree will get you in to be eligible to file for a national interest waiver. And even if you do not have 10 years of experience, you can replace that with a different criteria. So for example, if you have less than 10 years of experience and no bachelor's degree, then you can file with, less than 10 years of experience, but you have a bachelor's degree, you can go forward with a bachelor's degree, a critical role for an organization, reviewing and judging the work of others, professional membership in an organization that requires outstanding achievement of its members. And regardless of what you think your situation is, I encourage you to get an assessment, have an experienced person with different uniquely tailored approach. Look at your case and determine if you're qualified. You can contact us at 443-329-2929 or at info@silmilaw.com. This roadmap process show, I'm going to go through the different roadmaps for different kind of visas at least twice a month. We today are discussing some successful approaches for national interest waiver. If there's a specific area that you are interested in learning more about, feel free to direct message us. We're happy to kind of, accommodate you. But understanding that self-petitioning, taking matters into your own hands, is a very, very important tool in order to qualify and advance your situation. And no matter what happens with your self-petition, it will not negatively impact you if you have an existing employer-sponsored process. So you can actually do both, and it will not negatively impact that. This live session is intended for educational purposes. Do not act solely based on the information provided in this video, and do not fail to act solely based on the information provided in this video. And feel free to contact us 443-329-2929 or info@silmilaw.com. Thank you, and we'll talk to you soon.